Just admit it, and you can be honest because it's just us right now. You've always thought about submitting a Form 1 for a machine gun, right? Right. We've all been there in our, well, constant moments. What if I told you that somebody did exactly that in a post-1986 world? Actually, in a very recent world. What if I told you that the ATF approved it? That's right. Today we're going to be talking about the case of Hollis v. Lynch, the time that the ATF approved a Form 1 machine gun. Let's get into it. So Jay Hollis gets a revocable living trust, and he files a Form 1 to the ATF to manufacture a machine gun in May of 2014. For those of you who don't know, very briefly, in order to take possession of a machine gun, a suppressor, short barrel rifle, short barrel shotgun, first off, it has to be lawful underneath your state, and secondly, you need to get federal permission by doing a Form 1, Form 4. There's some other forms as well, but typically a Form 1 or Form 4 in order to get possession of it. Topic for another video. The bottom line is that Hollis did a legendary move by trying to do a Form 1 machine gun in a post-1986 world. More on that in a moment. Then on September 8th, 2024, yeah, September 8th, remember the 5-month turnarounds, he gets approved. 2 days later, however, he gets ATF'd, and they say, oops, this was granted an error, and by the way, if you made a machine gun, you need to go ahead and destroy that, because otherwise that's a felony. The letter stated that the ATF may not grant any private person's application to make and register a machine gun after May 19th of 1986, which is a reference to something called the Hughes Amendment to the Firearm Owners Protection Act. If you want me to do something about that, let me know. At any rate, though, Hollis files lawsuit, and away we go. Now, his lawsuit brings up 5 claims, and some of these claims are, frankly, very technical and probably wouldn't be too interesting to be talking about in a YouTube or online video to all but the most hardcore of civil litigation enthusiasts. And I don't even put myself in that category. Accordingly, I will skip the vegan kale salad portion of the lawsuit and push straight through to the steak and loaded baked potatoes portion. You're welcome. The Second Amendment challenge. So the Second Amendment reads, quote, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed, end quote. So the U.S. Supreme Court has explored the meaning of the Second Amendment in a number of very important and critical recent U.S. Supreme Court decisions. The first big one came in 2008, the District of Columbia v. Heller, where the plaintiff challenged a D.C. law that was basically a complete ban on private handgun ownership. In striking down the law, the court held that the Second Amendment codified a pre-existing individual right to keep and bear arms divorced from militia service. The court also went on to deal with the whole question of what does it mean to have a militia and how does this play into the whole thing? Not the topic of this video. So the U.S. Supreme Court, both in the Heller decision as well as the very important follow-up decision called McDonald versus City Chicago, would go on to state, quote, self-defense is the central component, end quote, of the Second Amendment. And both of those decisions would basically be used to go on and they would say things like the Second Amendment is about the defense of hearth and home. And because the American people have considered the handgun to be the quintessential self-defense weapon, a complete prohibition of their use is invalid. These decisions and their reach go far beyond handguns, however, because the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. Prima facie means basically on its face. So in other words, all weapons that are bearable arms, prima facie, in other words, the needle starts on the fact that they're protected by the Second Amendment. While Heller recognized the right of individual Americans to keep and bear arms, it also recognized that, quote, like most rights, the right secured by the Second Amendment is not unlimited, end quote. The court then went on to give a non-exhaustive list of long-standing prohibitions on the possession of firearms that are presumptively lawful in the eyes of the court and pass muster, so to speak, under Heller. Quote, nothing in our opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive locations, such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms, end quote. While those long-standing and presumptively lawful measures are one set of limitations, Heller recognized another important limitation on the right to keep and carry arms. That limitation comes from United States versus Miller, which was a 1939 case which dealt heavily with the National Firearms Act, which was passed in 1934, and a case that represented the Supreme Court's only analysis of the Second Amendment in the entire 20th century. In Miller, the defendants were arrested for, among other things, transporting an unregistered sawed-off shotgun and thereby violating the National Firearms Act. Miller upheld the National Firearms Act against a Second Amendment challenge, however. If you want to see, by the way, more about that particular case, U.S. v. Miller, of course, let me know in the comment field, but for now, we press on. So now pay attention because we're getting to that steak and potatoes part. In Miller, the court ruled that a short-barrel shotgun is not protected by the Second Amendment because it is not a piece of ordinary military equipment, and a short-barrel shotgun cannot be used to contribute towards the common defense. So Miller kind of looked at this as a two-way test. It's not ordinary and common military equipment on the one hand, therefore the Second Amendment does not protect it. And on the other hand, it's not used to contribute towards the common defense. Right. So Hollis, seizing on the opportunity in his lawsuit when he went to register an M16 via Form 1, decided to walk through that wide open door left by the Miller court and simply argued in his pleadings, if evidence is presented that an item is part of ordinary military equipment, then it is protected by the Second Amendment. And because an M16 is the quintessential militia-styled arm for the modern day, Hollis argues he has the Second Amendment right to possess one. Yes, the gun form and Reddit gotcha moment that we've all been waiting for. Unfortunately, so reasoned the Fifth Circuit in the Hollis decision. Not so fast. The court said no. Heller soundly rejected this interpretation of Miller. Particularly relevant for the court, Heller referred to machine guns as the quintessential example of why that reading is wrong. Read in isolation, Miller's phrase, quote, part of ordinary military equipment, end quote, could mean that only those weapons useful in warfare are protected. That would be a startling reading of the opinion, the court said, since it would mean that the National Firearms Act restrictions on machine guns might be unconstitutional. Machine guns, of course, being useful in warfare back in 1939 when the NFA was challenged in U.S. v. Miller. The court held that Miller must be read in tandem with what was, quote, the traditional militia, end quote, which was a pool of men bringing arms in common use at the time for lawful purposes like self-defense. The weapons brought to militia duty were the sorts of lawful weapons that they possessed at home. As a result, Heller read Miller to say that only that the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes, such as short-barrel shotguns. Heller therefore distinguishes between two classes of weapons. And again, follow this because this is important. You're going to keep seeing this come up again and again and again. Number one, those that are useful in the militia or military. And number two, those that are possessed at home and are in common use at the time for lawful purposes like self-defense. The court ruled that the individual right protected by the Second Amendment applies only to the second category of weapons, though that category at times may overlap with the first. So again, the second category being those that are possessed at home and are in common use for lawful purposes like self-defense. Those are the ones that are protected by the Second Amendment, although they may overlap with the types that are useful in militia and military service. Again, this is not me talking, I'm explaining the court. The Second Amendment does not create a right to possess a weapon solely because the weapon may be used for militia or, of course, by the military. So yes, the legalized recreational nukes t-shirts may be fun, but this is the lawsuit and this is the reasoning, I should say, really, that kind of shoots it down. So, by the way, this also reminds me of another case, which is kind of interesting, where the U.S. Supreme Court, in the case of Catano v. Massachusetts, struck down a state court ruling. There in the state courts in Massachusetts, the court upheld a stun gun ban in part because the state court found that stun guns had nothing to do with basically military service. They were not readily adaptable for military use. The court in the Supreme Court vacated the Massachusetts court's findings, explaining that, quote, Heller rejected the proposition that only those weapons useful in warfare are protected, end quote. Gaetano reaffirmed that whether a weapon has a nexus to military utility is not the test to whether the Supreme Court and the Second Amendment should give protection to a particular weapon. So stun guns, fine, even though there may not be the most, adaptable reason for military purposes, though of course I'm sure that there's some sort of unit out there that uses them. And so with that, the court basically tips the dominoes and watches them fall by ruling that M16s are not common and that Heller signaled them out as being dangerous and unusual weapons. In one case, the court noted that they classified machine guns and pipe bombs in the same category, noting that both were, quote, primarily weapons of war and have no appropriate sporting use or use for personal protection. That was in the case of U.S. v. Jennings. In another, the court ruled on the, quote, inherently dangerous nature of machine guns, end quote. That comes from United States v. Golding. And again, don't get angry at me. I'm only reporting, not pontificating. Obviously, any firearm is inherently dangerous, just like cars and planes are inherently dangerous. And so are gas stations with gasoline pumps. And I get it. I get it. The court ruled that machine guns are also unusual. There are approximately 175,977 pre-1986 civilian-owned machine guns in existence. Machine guns are banned outright in 12 states. And the combination of these two facts gave the court enough standing to basically decide that, look, machine guns are not common enough to be considered common. Now, before I get to the last argument, which is an interesting one that Hollis threw out there, dealing with weapons being used to protect against government tyranny, I just want to thank you if you made it this far in this video. It not only is fantastic to know that people are actually finding this interesting, or perhaps you just walked away and forgot about this. Either way, thank you. If you have, please consider giving this video a thumbs up, sharing it around in order to support us and the algorithm, and of course, subscribing to make sure you do not miss out on any future content. Also, if you want to see a video where we do a deeper dive specifically on what makes something dangerous or unusual weapons, of course, let me know in the comment field. Hollis then goes on to argue, and this is one of the quintessential Second Amendment arguments, we need M16s in order to protect the right of the people to alter or abolish the government, which may descend into something that becomes destructive and to destroy the people's rights. Basically, this is the tyranny argument. We need the Second Amendment to protect us against a tyrannical government. Hollis seeks equality, basically, between the people and the government in this argument as far as, look, if the government is this, we need that because that's how we check against tyranny. And the court says, no. The court declares that, look, the Second Amendment is about self-defense, not revolution. Self-defense is the central component of the Second Amendment. And there you have it. Hopefully this video was interesting. We covered a lot of great ground on this. Thank you for sticking around this long. As always, I look forward to seeing you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.